Now, the multi-billion-shilling 5-year Kenya Health Cooperation Framework with the United States suffered a setback Thursday after the High Court suspended its implementation. High Court Justice Bahati Mwamuye, in a ruling, halted its implementation pending the hearing of a case filed by the Consumer Federation of Kenya and Busia Senator Okiya Omtatah, who allege the deal violates the data laws when it comes to medical data, among other issues. Our reporter Ruth Wamboy has details of the legal battle ahead.
The Office of the Attorney General, and she's here, went through the agreement with a tooth comb to make sure that when it comes to matters data, the law that prevails on data that belongs to the people of Kenya is the Kenyan law.
A day after President William Ruto dismissed claims the 208 billion shilling Kenya-US Health Cooperation Framework would expose Kenya's medical data, the Consumer Federation of Kenya and Busia Senator Okiya Omtatah moved to the High Court challenging the deal's legality. In court papers, Kofek and Omtatah argue the provision on data transfer violates constitutional safeguards and exposes Kenya's medical information to misuse.
And we want to assure Kenyans that there is nothing that is untoward, there is nothing that is strange, there is no personal information that is in that document.
The court was further told that consumers as primary beneficiaries and sources of health data were never involved before the deal was sealed, and that it violated several laws in the Constitution.
It must submit to the Bill of Rights and things like those. It cannot just be that because we need some money, therefore we sell our birthright. And we talk of birthrights and selling birthrights. I'm sure you remember the story of Esau and Jacob in the Bible, where Esau sold his birthright for a bowl of soup.
The court further added that the deal would overburden the already burdened Kenyans, since Kenya committed to match U.S. funding estimated at US $850 million in additional health spending.
To reject that kind of arrangement and to demand that the domestic law is applicable to any contract, and any treaty that is signed must be subject to the Constitution of Kenya.
Following the petition, Justice Mwamuye ruled the implementation of the deal signed on 4 December in Washington, D.C. be halted pending the hearing of the case. He further directed both parties to serve the respondents with the petition and court order in both hard copy and soft copy, and slated the matter for mentioning on 12th of February 2026 before Justice Lawrence Mugambi for compliance and further directions.
And if need be, the final decision might come out of the Supreme Court. This is a matter of life and death. This is an existential threat to the identity of the Republic and to the fundamental rights of the individual as a human being with the dignity that must be respected and obeyed.
The development puts the government in a predicament as the legal battle begins. The petitioners had stated that the deal had violated several laws and data breaches, which could make Kenyans more vulnerable as they could be used as guinea pigs. Ruth Wamboy reporting for Prime Edition from Milimani Law Court.